Welcome to the Injustice Anywhere podcast.
Tonight we'll be discussing the Cameron Todd Willingham case with attorney and Injustice Anywhere Advisory Board member Michael Scadron and New York Times bestselling author and Emmy Award-winning filmmaker Mark Olshaker. I'm happy to have them both here tonight. This is a case that Injustice Anywhere hopes will eventually work to shine the light on the flaws of the death penalty in this country. Cameron Todd Willingham was convicted in 1992 of igniting a fire in his home in 1991 that killed his 3 young daughters. He was sentenced to death in Texas. Willingham insisted that he was innocent up until the date of his execution. 4 days before his execution in 2004, Willingham's attorney presented expert evidence refuting the State Fire Marshal's claim of arson. They asked the Texas Board of Pardons to commute his sentence and also asked Governor Rick Perry for a reprieve. Both of those requests were ignored. Willingham was executed on February 17, 2004. I would now like to introduce our guest to the show. Hi, Michael. Welcome to the show.
Hi, Bruce. Thanks for having me. I appreciate it.
Absolutely. Hi, Mark. Welcome to the show.
Hi, Bruce. Same here.
As I mentioned in the intro, Michael, you're a member of our advisory board. Can you tell us a little bit about your career and what was it that drew you to take an interest in wrongful convictions?
Well, I'm basically a retired senior trial counsel with the United States Department of Justice. I do not have a criminal law background, however. I was mostly in the civil division, and I was there over 30 years, and for the last 20 years I was doing environmental tort cases, and the centerpiece of a lot of those cases was the reliability of scientific evidence. And basically, since 1993, when the Supreme Court decision in Daubert came down, I held any number of Daubert hearings challenging the credibility of our opposing team's experts in the areas of toxicology, epidemiology, various medical specialties, groundwater hydrology. So I have some experience with scientific evidence, although not again in the criminal context. That's pretty much it.
So at the time of your retirement that you became interested in pursuing wrongful convictions, or is this something that's been a life's passion?
Back when I was going into law school, I remember of the boxer Hurricane Carter, Reuben Hurricane Carter, and I remember reading a very long article about him, and I think it was either Life or Look magazine, one of the now defunct magazines, and become angry. I was shaking about it. So I've had a long interest in it. I really got upset in the 80s and 90s with some of the mass child abuse cases that I thought were nuts in our country. And now in retirement and with the advent of the Internet, I became much more involved in the Amanda Knox case, which I believe is breathtaking in its absurdity. So I really got interested in that, and now I'm getting more and more involved in it because I have the time in retirement, and more so than I used to have.
Well, we're happy to have you aboard. Mark, you have an impressive resume. You're a New York Times bestselling author and an Emmy Award-winning filmmaker. Can you tell us how your career led you to team up with FBI profiler John Douglas to create Mindhunters?
Yeah, as you mentioned, I am a writer, author, and documentary filmmaker by trade, and I had written a number of thriller mystery novels that had done reasonably well, so I was able to support myself, and also did a lot of documentary film work for PBS. And after... This is almost cliche, but after reading The Silence of the Lambs, I thought, gee, the real story behind it must be really interesting. And so I went to the executive producer of Nova, the PBS science series, and said, why don't you let me do a program about the real story? And we were one of the first ones in, so actually we were welcomed by the FBI at this point. And the more I got to study and learn about this unit at the FBI Academy in Quantico, Virginia, the more fascinated I became. And I got to know the unit chief, John Douglas, who was this legendary figure in law enforcement. We did the film. The film was called Mind of a Serial Killer. It did quite well on PBS. And when John retired, he called me and said, "Are you interested in my story, and do you think anybody else would be?" And I said, "Well, I am. Let's see who else is." So we wrote a proposal, and publishers were very interested. We wrote a book called Mindhunter, which became a major New York Times bestseller, and they asked us to write another one, which we did, called Journey into Darkness, and it just took off, and we kept going. So we're now on, I think, our 9th book together, Law and Disorder, which has just come out in paperback and deals with both the Cameron Todd Willingham case, which we're going to talk about tonight, and also the Amanda Knox case, which is how you and I got to know each other, Bruce. Let me just tell the listeners, you've done tremendous work on the case. Your book is on my shelf and was one of my reference works when I was writing about the case and trying to understand it. And so we seem to have a commonality of purpose here.
Well, thank you for the kind words. There's many people that have come together in our group, and I'm just proud to be a part of it.
And
Michael?
I'm honored to be here with you, Mark Olshaker. I think you've done fantastic work, and I've loved Law and Disorder. It's just
thank you, Michael. It's very much appreciated, and I know John Douglas does as well.
And I've got both of your books.
I purchased that book on Amazon on Kindle. I have all the books on Kindle. I read them right on my computer with Kindle Reader. I recommend all of our listeners, if you haven't read the book, Law and Disorder, go to Amazon tonight and get yourself a copy. It's good reading, absolutely.
God bless you for saying so, Bruce.
If you want to come up to speed on the Amanda Knox case and you don't want to read a whole book like Bruce's book or a really long book, I think these last few chapters in Law and Disorder on the Amanda Knox case is the best summary of the case you can possibly get to.
Now, you and John also have a website that I link quite often, mindhuntersinc.com.
Right. Mm-hmm.
Now, how long have you been operating that website?
We've been doing that for about 2 years now, and we have news about ourselves and our books, and post stories and columns every time we have something that we want to talk about. As you know well, Bruce, we've done a number of columns about the Amanda Knox case and the absurdity of how it worked, and we've recently done a couple of columns on the Ray Rice case and domestic violence, and so we're kind of all over the board. But I think one of the things which I assume we're going to talk about tonight, which just carries through throughout, what is the commonality about all these cases we're talking about and all the cases that you now work on, Bruce? And I think the commonality is what I would call, and I think Michael will agree, is what we call confirmation bias, which is a case, the way the police present it, the way the media present it, the way the prosecutors present it, seems to uphold an already held idea, worldview, or whatever, and it's even with evidence, it's very tough to overcome what I call a good story, particularly in the Amanda Knox case, if that story is better than what actually happened.
Right.
That's absolutely true.
Certainly comes into play in the Willingham case.
Certainly.
When the testimony by the state field marshal and the local fire inspectors was so strong and so persuasive that it even persuaded some of the eyewitnesses, the neighbors and others, when they began to believe that, when they heard it, started to change their
We're going to get
story.
into all the details of the case, because it was overwhelming in the media, and he was really it was stacked against him from the beginning. But before we get into those details, let's paint a picture of the Cameron Todd Willingham case. What was his life like before the fire took place? Mark, I know in the book, John, you give a good summary of events. Can you tell us what life was like for Todd Willingham before the tragic fire that took the lives of his daughters?
Yeah, he was what most of us would call a loser. He had some alcohol problems. He's had some anger management problems. He had known the woman who became his wife shortly before all of this for a while. Her name was Stacy, and they had been on and off together. He admitted to having domestic abuse problems, which she was the unfortunate recipient of, and they finally got together, stayed together, and decided to get married. They had 3 little girls, twin girls who were babies and a toddler, and they'd hoped that would keep them together. And what's interesting is, while Stacy was very clear about Todd's hitting her, she made it very clear that he never hit the children and never abused them in any way. And what happened on the day in question was, it was shortly before Christmas, 1991, was it, Bruce?
Right.
Yeah,
right.
And Stacy was out shopping for Christmas gifts, and Todd was home alone and asleep, apparently. And what he says happened is that his toddler came into his room very lightly dressed, just what she was sleeping in, and said that there was a fire. He told her to run out. He tried to get the 2 twins out of the back, apparently, but the fire was too strong. He ran out the front and shouted to the neighbor to call the fire department. As Michael said, a number of witnesses, a number of the neighbors, thought that he seemed quite hysterical, but then changed their story after the fire marshal's report came out. Now, we're getting a little ahead of the story, but basically, all 3 girls died in the blaze. The autopsy report said it was from smoke, carbon monoxide poisoning due to smoke inhalation, and the 2 fire arson inspectors who came to the house the next day, who were very respected, one was a state worker and one was from the local Corsicana, Texas fire department, and they decided conclusively that the fire had been intentionally set, and they noticed what they thought was strong evidence of accelerants used, which is a sort of the smoking gun, if you will, for
and this information quickly spread throughout the media.
Correct.
What you had mentioned before is some eyewitness statements from neighbors changed from before that information was available until afterwards.
Right, and Michael, as a lawyer, I'm sure can confirm that this is a very common phenomenon. So as soon as you change the context of what people think they saw, then, or what they heard, then it changes their memory of what they had.
Absolutely. I mean, memory changes. It's malleable. It's going to be affected by contextual information that is fed, and the psychologists as well as lawyers will know that, and will tell you that. And that's what.
Now, Mark,
here.
John, in the book, he described the soot patterns in the house.
Mm-hmm.
Did they match the believed telltale signs for arson at that time? Was that the believed science of the time?
That was the belief science, and in fact, they found what they thought was was evidence of accelerant in the girl's bedroom in the shape of a pentagram, which to them meant some kind of satanic worship. They were also very suspicious of the fact that when Todd ran out of the house, he was wearing only his jeans, he was barefoot, and yet his feet, even though he said this was a terrifically intense fire, his feet were barely blistered at all. So that seemed to them very suspicious, along with the what they called the scorch patterns along the main hallway. So that's where the case went to the jury. That's what the jury heard, and along with that, as Michael alluded to, they had experts who claimed that the fact that Todd Willingham was into heavy metal music, Megadeth, Metallica, that he had posters of Iron Butterfly up on the wall. We use in our book a photograph of him on death row that prominently shows a dragon tattoo on his arm. That was all taken into consideration by the prosecution and as evidence that he was that he had a violent personality and that he was very interested in death and satanic worship.
And they
together those two things. together those two things, particularly the expert witnesses on the fire department, sealed his fate with the jury.
And they
linked that with what they perceived as a pentagram on the floor.
Mm-hmm. Yes. Now, do you want to get
Michael,
to the next step? Yeah.
Sure, Michael, we discussed this earlier today. Todd's actions, he ran right out of the house. To me, before I even read Law and Disorder, the first thing I thought was, why didn't he grab that girl that came into, his daughter that came into the room to warn him that there was a fire? If I'm a dad, the first thing I'm going to do is put her under my arm and run out of the house with her. She's coming with me.
Yeah, instead he told her to leave the house, and then he was
told her to leave the house.
Really, yeah, I don't think he had all the marbles. She had woken him up crying, "Daddy, Daddy," and of course he told her to leave the house instead of grabbing her to go out because he wanted to look for the babies, and eventually his hair got seared, and he was barely conscious. And
do you believe his actions are genuine? Was the witness statements that he tried to go back into the house, were his actions, did they show that he was actually trying to save his kids?
Well, I think they did, because he was taken, the authorities dragged him over to the fire truck, and there were several times when he tried to go back into the house, and he had to be restrained. The neighbor really kind of changed her tune. She had originally said, well, she had left, and he was trying to break in and break into the windows, which he did. And then later on, she said, well, he was doing this for a show. But that later on was after she had read the fire marshal's report and was influenced by that. I mean, it's very, very difficult to judge behavior when you're in that kind of a stressful situation, and we know from other cases that people's behavior vary under stress.
I'll underscore that, and generally we can take almost no behavioral inference from that kind of thing, because everybody does respond to that differently. One of the cases I've written about before, and that we've done another program for Nova on, was the 1932 Lindbergh kidnapping case. And a lot of people accused Lindbergh of either being heartless, cold, distant, or even being part of the conspiracy to kidnap his son because of his completely detached and unemotional response. On the other hand, you have to look at a guy like this and say, this is someone who is used to being in control, not getting rattled, not getting shaken up. This is somebody who decided for the first time to fly across the Atlantic Ocean on a tiny, flimsy plane that didn't even have it had one propeller and didn't even have a front window, and he had to stay awake and fly it for 33 straight hours. This is a guy, if you're the kind of guy who gets rattled and out of control in a stressful situation, you're not going to make it. So you've got to take all of these things into consideration, plus the unpredictability of human behavior.
That's why I brought up that one situation, because that's the only thing that really stood out to me during the fire. But when you step back and look at the big picture, it doesn't mean a whole lot.
Correct.
Now, so he's charged with murder. He goes to trial. His trial only lasted 3 days. And from what I've read, the prosecution attempted to bolster their arson case with the testimony of a jailhouse snitch named Johnny Webb. I have my own opinions on jailhouse snitches. The Jamie Snow case is one that just full of jailhouse snitches that were completely unreliable. So I'm a little biased in the whole jailhouse snitch conversation.
Yeah,
so I was hoping both of you could chime in.
Bruce, let's talk about that for a minute, and I'd like to get Michael's opinion, because what the prosecution always tries to show with the case of a jailhouse snitch is they're doing this on their own and they have nothing to gain by their testimony. That is never, ever true. A jailhouse snitch always has something to gain by testimony and cooperation, and so sometimes jailhouse snitches are accurate, but I would like Michael's opinion as an attorney. I would think they always should be regarded with a healthy degree of skepticism.
Well, I think they are, and I think they should be. But again, when you have, the scientific evidence, which is the linchpin of the case, if the jury's going to go any way, you want to influence them by throwing as much dirt as you can, and by making the person seem like a bad man. And if he confessed to this jailhouse snitch, I think the prosecutor, this fellow Jackson, told the jury, take it or leave it. But what you have to do ethically is if the fellow is being offered something, that has to be disclosed to the defense so they can at least cross-examine him and undermine the credibility. And in this case, there were favors being offered. They actually reduced his charge from aggravated robbery to robbery in the second degree, and they promised that they would do whatever they could to reduce his sentence. And they actually had him transferred from prison to the local jail in order to keep him safe from other prisoners. But so there were a lot of favors here. None of that was really disclosed to the defense, and of course the favors continued all the way up through the execution and beyond. He became very disenchanted and then recanted, and then they tried to keep him in line with coming forward with whatever, and he recanted the recantation based on what I read in the recent Washington Post article. He's basically come out more recently and said there was no confession. This was all what it's about, and he's come clean.
But let's be honest. Let's be honest. Yeah. All three of us, had we been on the jury and received this expert testimony that there was definitely an arson, and Todd Willingham was the only adult in or around the house at the time, I'm afraid I would have voted for conviction as well.
I agree with you, and Bruce and I talked about that earlier today. I think it would have been the evidence was compelling. I mean, how are you?
I would have seen no other option other than guilt.
Yeah, the evidence was compelling.
Now, before the trial started, the prosecution offered him life without parole, correct?
Correct. Yeah. And he said,
and he was adamant about his innocence.
And his two court-appointed lawyers urged him to take it. They assumed he was guilty based on the evidence, and he said, I'm not going to plead guilty to something I didn't do.
Right. And even the expert witness they retained believed he was guilty, and so they never put on that expert witness. The only witness that testified for Willingham, he wanted to testify. They didn't think he'd be a good witness, so they didn't let him, or they at least advised him not to, and he didn't. But the babysitter testified that he would never hurt those kids, in her opinion. But that was the only witness that he had. He suffered from having being an impoverished person and having to have two court-appointed lawyers who didn't even believe in him. It stands in stark contrast with the case of an inmate of his, a fellow inmate, Ernest Willis. Now, the two cases were later presented to the Texas Forensic Science Commission. That's down the road. That's after his execution. And they were presented for review. Ernest Willis, who was his inmate, had a remarkably similar case with the same kind of fire and the same kind of testimony based on not the same people testifying, but also the State Fire Marshal's office and the local fire officials claiming that all the old myths and folklore about these indicators of arson had to be true. But the big difference with Willis is he had a lawyer from a big patent firm in New York doing pro bono work. So they had the resources, and this lawyer believed in his innocence, so they had the resources to really look ahead, and they came up with this Gerald Hurst, which is the same fellow, Jeffrey Hurst rather, a chemist with a PhD out of the University of Cambridge, a brilliant man who was a fire scientist, and gave the report in 2004 that led to Willis's exoneration, but did not help Willingham, who was executed same year, 2004.
But I think we have to say why this happened, Michael, and the reason is because Willingham's appeals defense team had located Hearst, who was living in Austin, Texas, and was a world-renowned expert. He analyzed the case pro bono, and he said all of the testimony was junk science, which had basically been refuted back in 1990 by the what's famous to fire and
the Lime Street. Yeah,
is the Lime Street in Jacksonville, Florida, and
exactly.
And so that had really turned fire science on its head. But by the time, this was several days before the scheduled execution, so this evidence was so. You can't say that anything happened wrong as far as the state goes before that, but this evidence was available before Willingham's execution. The State Board of Pardons and Paroles refused to consider it, and Governor Rick Perry refused to consider it.
And this was 4 days before the execution, though. We're jumping ahead here a little bit, but what took so long for this evidence to become available in this case for Willingham?
What did you say?
What took so long for this evidence to become available in Willingham's case? Why did it take so long for his defense team to bring this forward?
Because this was not widely known by a lot of people, but it just so happened that I believe a relative, if I remember the story correctly, a relative of Willingham's saw Gerald Hearst on a television program and then contacted him. And these things take time, of course. They had to get him all the evidence and everything. But Hearst was absolutely straightforward. He said, this was not an arson. And, of course, the listeners have to remember that arson is a very particular kind of crime because in most cases, you know a crime has been committed. You know somebody has been hurt or suffered or robbed or wronged in some way. And what you have to do is figure out who did it and catch them. With arson, you have one more step because, first of all, you have to decide whether a crime actually was committed or not, or whether it was an accident. And what Hearst said was unmistakably, this was an accidental fire. This was not intentional. So the evidence was there, and again, we may be getting ahead of our story, but they then brought in another fire expert named John Lentini, one of the best in the world, out of New Orleans, and he looked at the evidence independently and said exactly the same thing.
This was after the execution.
Let me just talk briefly about the Lime Street fire because that involved Lentini.
Right, I want to get to that, but before we do that, because this go all the way back to the trial, the prosecution's expert took the stand and laid out 20 indicators of arson.
Yes.
Were they all completely junk science? Was the entire thing incorrect?
Well, all I can tell you is that Gerald Hearst refuted them point by point in a very compelling way.
Okay, and this new evidence from Hearst was related to this recreation, this fire recreation that Michael's going to describe now.
Right. They used to believe that a fire burned much faster and hotter with an accelerant than, for example, a wood fire would, and they were wrong about that. Most of these fire inspectors who testified are not scientists. They've had very little education, and whatever experimentation they did were controlled fires that were snuffed out before flashover. Flashover is that point where the radiant heat becomes so hot at 1100 to 1200 degrees Fahrenheit that everything in a room that's combustible will explode, and that can get spread to different rooms. In the Lime Street fire, there was a fella, Lewis, who owned a home in Jacksonville, and this was in 1990, 2 years before the Willingham trial. And his house burned, 6 people were killed. He was charged with arson based on the old indicators, the pre-flashover indicators, that floor patterns and crazed glass and V patterns on the walls, all of these things. And Lentini was one of the scientists involved, and he believed that Lewis was guilty. But there were questions about when the samples were sent to the lab, and they couldn't identify a petroleum product or misidentified it. Questions arose. The house next to Lewis's house was condemned, So they decided to do an experiment. They spent $20,000.
And it was essentially the same house, right, Michael?
It was essentially the same house, and they refurbished it with the same types of furniture, carpet, all the same materials. Spent $20,000 in doing this. And guess what? Lo and behold, the fire burned just as hot and fast as if an accelerant was used. They lit the couch on fire, because that's what Lewis has said his kids playing with matches, and it burnt it the same way. And since it went to Flashover, what they learned was that once you have that kind of burning, that is, everything in a room goes up into flames, and the room is engulfed with flames, and it spreads to other rooms, that many of the same indicators, floor patterns and V patterns, also appear. But they never understood that. They never understood that the effects of flashover would lead to the same indicators, and there was simply no way to discriminate by deciding whether an accelerant was used or not.
I think that's an excellent description, Michael. And my understanding is that at the flashover point, in other words, the point where whatever's on fire takes over and sets the whole room on fire, fuel becomes unimportant and air becomes important.
Exactly. The ventilation then controls where the fire goes, which is what happened in Willingham's case. You had the kids' bedroom, the hallway, and the front porch all burnt down, and these were contiguous. So it's the effect of flashover that happened. It wasn't the testimony at trial was that this meant there were multiple origins, that he had to use an accelerant in the kids' room, in the hallway, and the front porch. That would only be true if these other rooms were segregated or isolated from each other, but not if they were contiguous, because once you have a flashover condition, it's going to spread from across the walls into the next room. So,
and what was fascinating and ironic is that Hearst concluded that the pentagram shape on the floor was created when all 5 windows in the room burst out and let in air.
Right, an excellent point. And this shows the folklore, the mythology that was really in effect before 1992, when you had the first fire manual that set forth the state of the art and the scientific method. You really had just sort of handing down these myths by people who were not scientists. They were fire inspectors, but they were not scientists, and they didn't have the kind of education or training that would have allowed them to have undertaken scientific analysis here.
I was just going to say, Michael, I believe that Hearst also said that Willingham's story about running out down the hall barefoot was totally consistent, because in a flashover situation, the fire would start at the top and work its way down the room, which is...
and he ran out of the house. It was pre-flashover.
That's what I was going to mention exactly, too. When he opened the front door, he provided the air.
Correct.
Exactly. That's what that helped the fire, leap out the windows and leap out the door and burn down, the front porch.
And another thing on the front porch, another thing that that Gerald Hearst noticed was that there was residue of chemical accelerant on the front porch. When Hearst examined photographs of the house before the fire, he noticed a charcoal grill on the front porch and a bottle of charcoal lighter fluid right there. So, in point of fact, from an evidentiary point of view, it would have been more unusual than not had there not been chemical residue there.
That's correct, and that was the only one of the 21 indicators that where samples were sent to the lab, and it found what could be called a kerosene mineral spirit. But the what you call lighter fluid was really fits that description. Mm-hmm. The scientific method, of course, we know now what they didn't know then, that you had to have a positive read from testing the labs for an accelerant. And in the Willingham case, like in the Willis case, In Willis, you didn't have any positive reads, even though the samples were in fact tested at the lab. And in the Willingham case, you had only that one read, which would have turned out to be the lighter fluid, which was a perfectly legitimate non-arson explanation. I wanted to add that Lentini was a scientist involved in the Lime Street fire, and he believed at that time all these old myths. He believed that Lewis was guilty. And he said that when they did that experiment and they burnt the house to the ground and they found out, to their surprise, that flashover led to the very same indicators, that was his epiphany. That's what changed him around, and Lentini became one of those 5 panel members on the Innocence Project's peer review in 2006.
Sure, yeah, we'll get to that in a little bit here about the current status, but it was that one, that's why it's well regarded, it was that one recreation that changed science as they know it today.
Well, that's correct, but they also did extensive follow-up research. So it was not just a single event. It was the triggering event for a whole new approach. And Lentini would go on to write what really became the landmark text called Scientific Protocols for Fire Investigation.
I want to touch base on this pentagram on the floor real quick, because you said the 5 windows blew out, causing that mark. Mm-hmm. It amazes me that this was even part of the case. They find Iron Maiden poster on the wall, and the guy's got a dragon tattoo, so they assume that he's into some kind of satanic rituals. Right. How much influence do you think it's had on the jury?
Thing. Well, I think it can have a tremendous effect. We saw the same kind of thing with the West Memphis 3 case in West Memphis, Arkansas, where 3 teenage heavy metal outside goth-type kids were accused, convicted, and sentenced for killing 3 8-year-old boys. And what's interesting about that case is it's very similar to what you and I have discerned about the Amanda Knox case, Bruce, which is there was no evidence. But that didn't stop a presumption that this followed a certain scenario, a certain narrative, and that narrative fit into what the prevailing wisdom and thought was about the defendants. And I think the exact same thing is true here for Cameron Willingham. Brandon Garrett, who I'm sure you all know is a law professor at the University of Virginia, published a book in 2011 called Convicting the Innocent, where criminal prosecutions go wrong. And Garrett identifies 5 common failings leading to wrongful convictions. False confessions, which of course you had in both the West Memphis 3 and the Amanda Knox case, junk science, which you certainly had here, jailhouse informants, ineffective assistance of counsel, which Michael has already mentioned in this case, and bad judging. So you had almost a perfect storm of indicators here.
He really had no chance. When you look at this case, looking back on it, he had absolutely no chance. The problem I have is the evidence became available 4 days before the execution.
Exactly.
How much to blame?
Actually, Bruce, I need to correct you there. The pardon board rejected that 4 days before. The rejection came February 13th. The execution was February 17th. So I think that the Hearst report was given to them perhaps a few weeks before that. I don't know exactly the timeline.
Well,
but
that even makes it more damning, I think.
Okay, yeah, I went by the Law and Disorder. It says that Law and Disorder says the pardon board received the information less than a week before the execution.
Yeah,
either way,
I suspect Michael is right on his chronology.
The time frame is short. How much blame can we put on the governor and the board at this point? Because all they needed to do was stay this thing for a couple months and look into it. Well, who would that have hurt? Who was hurt by staying in execution for a few months to look into new evidence?
Well, you're preaching to the choir here.
Michael, I was just about to say the exact same thing.
Yeah, there wouldn't have been anything, Governor Perry.
What's the downside to it?
But one of the pardon board members spoke up afterwards, and what he said was, "We're not going to look at there's always new these reports unless there are glaring errors We just want to make sure that all the I's are dotted and the T's are crossed and that there are no glaring errors. Otherwise, we're not going to get into all of this. This just contradicts what some of the Supreme Court justices have said should be the fail-safe for when the courts can't look at new evidence. You always have the option to go to the governor. Well, guess what? That's no option at all. So there is no fail-safe in a system where the courts won't look at new evidence or the courts won't allow you to reopen a case and prove innocence. Then you go to the governor and they don't look at it. So it's really a catch-22. It's just a very flawed system, and that's particularly true in Texas, where the pardon board, I think, is only out of hundreds and hundreds of pardon requests and death penalty cases, they've only granted one in history.
And let me editorialize a little bit to say that this particular governor, Rick Perry, doesn't put a great amount of faith in science to begin with. Right. He has come out politically, publicly, and said that creationism should be given equal weight to evolution in the public schools, and so it is horrifying but not surprising that a man with this mentality would not reconsider new science, new scientific evidence in a death penalty case.
That's an excellent point. My question is, did Rick Perry even look at the evidence before the execution, or he just brushed it off his desk?
Well, we know he made a statement.
Yeah.
And his statement said that basically this guy is a snake, he's horrible, he's a monster, so we're going to execute him.
But I believe he made that statement after the execution because he based it on Willingham's comments about his wife, Stacy, right before he was going to be executed. He went off on her because she's a woman that stood by him during trial, but at some point in time over the years, she turned on him, and she believed he was guilty, apparently. So he went off on her right before he was to be executed. I think he had the right to be angry, because he was an innocent man being put to death, and he was expecting this one person in his life to stand by his side. And Rick Perry comes out after the execution and says, he's a monster. Look how he talked to his wife.
Right, and he's of course a politician, and he doesn't want to be soft on the death penalty, God forbid. Of
course.
And
I want to talk about the politics a little bit, because in 2005 there was a Texas Forensic Science Commission that was started, and from what I read, Rick Perry tried to stop it.
Well,
now,
that was later on down the road.
This is in 2005. So now the Innocence Project is involved.
He got rid of the director who wanted to reopen the Willingham case.
And that was
so the Innocence Project is involved. They bring in new experts. Multiple experts have now agreed with Hearst. So it's pretty much unanimous that the science was wrong at trial. And Rick Perry's trying to step in front of that and silence it. Is that correct? Am I reading that wrong?
I think you're reading it exactly correctly.
Yeah. That's right. And another scientist, Craig Byler, I guess his name is, Craig Byler, was doing a report for the Texas Science Commission on both the Willis and Willingham cases. These cases were presented to the commission by the Innocence Project that wanted them to review it, and they accepted that. But just because it came out that Byler was going to come out with a scathing testimony, it was just days before he was to testify before the commission, that Perry stepped in and fired the head of the commission and delayed the testimony. Eventually, Byler's report came out, and it is attached as an exhibit to the final report, which is a good thing, but it was a scathing damnation of the testimony in the Willingham case, saying that they should have known better. Then the Texas
what led to the Texas Forensic Science Commission being created? Was it this case in particular, or are they looking at many cases throughout Texas?
No, it was created to for any cases that came up to show misconduct in forensic science. So they reviewed these cases because the Innocence Project submitted them. The Innocence Project got involved in 2006. It said, based on heavily based on Hearst's analysis, wanted the Willis and the Willingham cases both looked at, because Hearst said when he looked at the Willis case, it was like he was looking at the same case. They were so similar.
Okay.
And
So the Innocence Project saw that the Texas Forensic Science Commission was created, so they took that opportunity to present this case to them.
Exactly.
That's right.
And they accepted the case, and they're just days before the testimony in around 2009 timeframe when Perry was running for governor again. He fired the head of the commission and delayed for some time. And Byler spoke out and he said, "There's politics has no place in forensic science analysis here." So.
Apparently, Rick Perry feels otherwise.
Yeah.
Well,
now,
you have three of the world's great arson experts: Gerald Hearst, John Lentini, and Craig Byler. And I believe Governor Perry referred to them as latter-day supposed experts. And
the irony, as I said, is Lentini was one of the old guard until that Lime Street fire turned him around completely.
My question is this science still being debated, or is this now the accepted science? Is it still heavily disputed?
No,
I don't believe so.
I don't believe so, especially since the Supreme Court in 1993 came down with the Daubert case, which, as you know, replaced the Fry rule. The old Fry rule was generally accepted in the science community. It would be all you have to show, but the Daubert required the scientific method, such as testability and a known error rate and peer review and all of that. Now, the arson lobby was very, very resistant, and they said our sleuths are not real scientists, so they shouldn't have to comply with the Daubert requirements. And they even filed an amicus in a court case that the Supreme Court then decided in 1999, 6 years later, that the Daubert ruling applies not just to science and medicine, but it applies to any expert testimony of a technical nature that requires specialized knowledge. And so with that ruling in 1999, the fire inspectors had no choice but to adopt the scientific method because they would have been excluded as experts if they hadn't. And so I think...
This was in 1999.
That was 1999.
A full 5 years before Willingham's execution.
Absolutely. There's no justification for that, as the Willis case shows. It was a combination of poor lawyering for Willingham as opposed to pretty good lawyering for Willis, but also a DA that was willing to listen and was influenced by Hearst, who he admired greatly, and said, if Hearst says it's arson, it's arson. If Hearst says it's not arson, it's not arson. In contrast to the prosecution in the Willingham case, which dug in its heels. But I think the lawyering, this is just a huge problem all over, from time immemorial, that poor people just don't have the resources. They get court-appointed lawyers who have very, very short on time and don't have the money to start hunting down the top experts in the country, and they suffer for that.
Many of these cases that we look at, how are they related? And I'll be honest with you, many of the cases we look at are related to a person who did not have money, that took on a public defender because that was their only means of a defense, and the results were very poor. I believe that there are similarities to all these cases.
Now, at the time that we wrote Law and Disorder, Gerald Hearst had been instrumental in overturning 10 convictions of people accused or convicted of arson. Now, to follow up Michael's point, how many others are there that an expert like Hearst could never even get to?
The old arson cases are being reopened because of this.
Mm-hmm.
So, yes, I think the scientific method has taken hold in arson cases, so we're not going to have a repeat of Willingham. But as Justice Blackmun said in the Daubert ruling, science is forever evolving, whereas in law you have to reach a quick and final resolution. So that has that presents a lot of tension for the death penalty, and the Innocence Project had an excellent recommendation that as science changes, you have to consider that like you would newly discovered evidence, so that you can present that in a writ of habeas corpus or in a motion to reopen.
Well, and the other thing you have to consider, as Bruce, as you well know from your own research on the Amanda Knox Raphael Solecito case, there all the science favored Amanda and Raphael, and that still wasn't enough.
Right.
As I said,
which is amazing. I mean, certain cases just have no rhyme or reason. That's one of them. Mm-hmm. But I believe in this
Amanda
case,
Knox case stands alone in its breathtaking absurdity.
It certainly does. I believe in the Willingham case, if science supported his statements in the beginning, if science supported that he ran out the front door and he opened the door and it blew the windows out of the bedroom, I don't think a conviction would have occurred. This is one of those cases where science says it was believed during that time, convicted him. And over time, science evolved. They learned. But unfortunately, the evidence wasn't heard in time in his case. That's the true tragedy
and
here.
Also, Willingham was not an attractive or sympathetic defendant.
Right.
Well, and that certainly did play a role here. I think
it was hard to like him.
Capitalize on that. But there never was a really good motive for his killing his children. When the State Fire Marshal asked why did he do it, he said he believed it was to kill. He set the fire to kill his children, but why? And that was never really answered, other than the fact that the DA thought, well, they got in the way of his lifestyle, kind of a Casey Anthony type of argument.
Right. They speculated because they really had no motive.
And yet, again, that's not an uncommon motive for the unfortunately not uncommon crime of murdering one's own children. But it didn't fit with the evidence here, and it didn't matter.
Right. Now, as we wrap things up here, I'd like to ask you both, because I wonder myself if cases like this will eventually change the current feelings about the death penalty. I know in Texas and Mississippi they're very strong. I don't know if those states will ever change their opinion on the death penalty, but other states certainly have. I know Virginia recently, Kirk Bloodsworth was instrumental in overturning the death penalty in that state. How do you both feel? We'll start with Michael. How do you feel about the death penalty in general, and do you think cases like this can have an influence on public opinion?
I think cases like this can. As you recall, Justice Scalia, in the 2006 case involving Kansas and a challenge to its death penalty, basically said that the defense couldn't cite a single case, or the abolition movement couldn't cite a single case in which it was clear, that a person was executed for a crime he did not commit. Because if such event had occurred in recent years, we wouldn't have to hunt for it. It would be, the innocent's name would be shouted from the rooftops. And then you have all these events with the new science raising questions. And in 2010, a Texas state court judge held a hearing on Willingham's relatives' application for a posthumous pardon, and he entered an order exonerating Willingham, and in that 18-page order at the conclusion he said, this court orders the exoneration of Willingham for murdering his 3 daughters. In light of the overwhelming, credible, and reliable evidence presented by the petitioners, this court holds that the state of Texas wrongfully executed Willingham. That order never became official because the state appellate court halted the inquiry while it considered whether the judge, Charlie Baird, had authority to examine the case. Baird eventually, retired from the bench, and as far as I can tell, the matter didn't go any further, except they went to the Texas Pardons Board, which denied a posthumous pardon just, I think, maybe even earlier this year.
That sounds right.
Is there any opportunities for the state to try to pardon him again in the future, or is it a one-time deal? How does that work?
I think they can come back just like you can with an extradition request. You can come back year after year after year. Because
if there's any case that would warrant a pardon, it's this one.
But it would embarrass a lot of people.
Right.
Absolutely. Maybe after Rick Perry's no longer governor, it'll happen.
if you have a Democrat, I mean, ex-governor of Texas, Mark White, was on Willingham's side here, so it really depends on who's in office. But it doesn't suit Perry to have this thing come up, and if he runs for president again, it's not going to happen.
Now, Mark, I'll ask you the same question. How do you feel about the death penalty, and do you think cases like this can truly influence the public?
I think they can influence the public, and they should. I have to tell you, John Douglas and I still favor the death penalty in limited cases, generally not for this kind of case, not for felony murder, because it's too difficult to figure out what actually happened at a moment's notice. We still favor it for predators, serial killers, that kind of case, and I still believe that we can put proper, in certain types of cases, we can put proper safeguards in place, not for this kind of case, but for predatory cases. And I have to believe that there are certain cases that the only moral avenue available to the state is to rid itself of these monsters. But I think I'm on the losing end. I think the death penalty will be abolished before too long.
I just think I'm against it because I think it's too difficult to make these distinctions, and I'm happy to see.
And that is a tough argument to counter.
Yeah, I think
you both make excellent points on it. My opinion has changed over the last few years, just with the development of Injustice Anywhere. I'll have to say, 5 years ago I was 100% for the death penalty, and now I've become pretty much against it. I will say that Mark makes some good points, because when I think back to Timothy McVeigh, I had no problem with him being put to death. So I guess that I do have that limited feeling too, but it has to be a very limited case. And if you get down to that limited number of cases, then I think that we could probably do without it, and those few people can sit in jail for the rest of their lives and rot away in prison. And I think we'll all be okay with it eventually.
And that is a defensible position.
So I really want to thank you both for being on tonight. I think this is an excellent case to discuss. I hope that some of our listeners will look into it a little bit more. We do have links on our website. If you go to the death penalty link on the left-hand side at injustice-anywhere.org, you can find links to the Cameron Todd Willingham case. But thanks for being on tonight. I really appreciate it.
Thank you, Bruce. Anytime.
Next week, we'll be discussing whether or not false testimony led to the wrongful conviction of Byron Case. Please join us for that show. You can listen to all of our radio shows in the Injustice Anywhere Radio Archive. You can find a link to the archive on our homepage at injustice-anywhere.org. Thank you for tuning in.